Today's session is we'll be discussing the powers of the commissioner, which is vested under him by virtue of Section 264 of the Income Tax Act. Now, Section 264 of the Income Tax Act has a very wide power. It gives power to the commissioner to do complete justice against any order which is prejudicial to the assessee. This particular section is a assessee friendly section in the sense that any assessee who is applying in this applying for an applicant for a revision in this particular section cannot be worsened off from where he is. So my first question would be, sir,
Yes.
can an application under section 264 be made if, say, there is an error? For example, my income is exempt, but I have not claimed that exemption, and I have not even filed my revised return to that effect. And it is after when the order comes, I am applying for revision under section 264. Whether this application would be maintainable, sir?
Good evening, everyone. Let us start today's session by reading of section 264 in the first place. It says that in case of any order other than an order to which section 263 applies, passed by an authority subordinate to him, the principal chief commissioner or the principal commissioner or the commissioner may either on his own motion or an application by the SAC call for revision of the record of any proceeding under this Act in which an order has been passed and may make such inquiry or cause such inquiry to be made and may pass such order, not being an order prejudicial to the interest of revenue. So I think it is very important to understand that any order, any order which has been passed by any authority below the authority of principal commissioner or the commissioner can be rectified. Now, that order may also be an order under 143 subsection 1, where there is no assessment as such, that is not a scrutiny assessment in the sense, but an assessment nevertheless, wherein on the basis of return filed, the faceless authority scrutinizes the return on its own, and on the face of it, if it is correct, then either refund is granted or if any shortfall in the payment of tax is there, then that is intimated. So in a way, it is an intimation. Now, coming to your specific question, whether any error committed by the SAC in filing of the return can be corrected. Now, here the power of the commissioner is such that he can not only correct the errors in the order passed by his subordinate authority, he can go even a step back and see whether ever there was any claim which the SEC should have made. For example, there is a benefit under section 10 and the SEC omits to make a claim in the return. Or for example, there is a benefit of, say, a deduction on account of donation. Or say there is a computation of income from business and some expenditures are left out. So there may be any type of an error, an accounting error or an error in law. But if it is brought to the notice of the commissioner under section 264, then he has very wide powers under the law to rectify those errors. And time and again, it has been recognized by various high courts, the High Court of Bombay High Court, the Karnataka High Court, the Gujarat High Court, Delhi High Court. So almost all the high courts in the country, Andhra Pradesh High Court. So almost all the high courts in the country has recognized this power of the commissioner under 264 to rectify any type of error.
So whether an order under section 264, will it be appealable before the income tax appellate tribunal?
So first of all, You see, before I answer that, I must point out that 264 power is an alternative power in the sense that either you, alternative power in the sense that alternative remedy, rather, that an SAC can choose to either file an appeal before the commissioner appeal or joint commissioner appeal, or he may choose to come before the commissioner under 264 if any error is committed by him, or if any order is passed in which he does not wish to pursue the remedy of the appeal, then he can apply for revision under section 264 only after the time limit for filing of the appeal has expired, or if that time limit is not expired, which time limit is 30 days, and within 30 days itself he waives his right to file up. so, so on satisfaction of either of the condition, he can approach the commissioner under 264. But once he approaches the commissioner under 264, then there is no appellate remedy under the law, either before the commissioner appeals or before the tribunal. And therefore, the only remedy is to file a writ petition under Article 226 before the High Court.
So suppose let's give a more practical insight to it. I have filed an appeal before the commissioner appeals. Now, for some reason, I wish to withdraw. I wish to withdraw that appeal and then file a revision under section 264. Will it be permissible?
You see, ordinarily, to the best of my knowledge, it is not permissible in the first place to withdraw the appeal. But there is a judgment of the Honorable Bombay High Court, I guess, which says that once you see what the SAC did that particular that particular matter is that he filed an appeal and he also filed a revision application under 264. Now he realized that he cannot have two remedies simultaneously, because it cannot be that with respect to the same issue you are pursuing remedy before two authorities. That is not impermissible in law. So he withdrew his appeal, and the issue arose that whether after that withdrawal, that application under 264 is maintainable. Honorable High Court said that in that case, the withdrawal of appeal was allowed by the appellate authority by an order that the appeal is dismissed and withdrawn. So once that is done, then it is as good as if no appeal was filed, and therefore the remedy under 264 is very much available.
So, what would be practical circumstances in which it would be advisable for an SSE to file a revision application under section 264 instead of filing an appeal?
So as we were discussing, that the power under 264 is very, very wide. And in my opinion, the powers are much wider than the power of the appellate authority. For example, before an appellate authority, the section 250 says that the joint commissioner appeal or the commissioner appeal may, at the hearing of appeal, allow the appellant to go into any ground of appeal not specified in the ground of appeal if the joint commissioner or the joint appeal is satisfied that the omission of the ground was not willful or unreasonable. Further, the income tax rules says that income tax rule 46A says that ordinarily the production of additional evidence is barred before the commissioner appeal or joint commissioner appeal. And only in exceptional circumstances, which is specified in Rule 46 capital A, the additional evidence may be allowed to be admitted. So there is a discretionary power to the appellate authority to either allow you to have the additional ground, that is the point of law, or allow you to bring on record any additional evidence. But that is not the case with the 264 revisional proceeding. Under 264, the power of the commissioner is very, very wide. So you are not, limited by the discretion of the commissioner to either permit you or not to permit you to raise any additional ground or bring into record any additional evidence. Rather, what the Honorable High Courts have held from consistently from time to time, that it is the bounden duty of the commissioner to ensure that no prejudice is caused to you. Now, here I will just like to read a judgment of the Bombay High Court in Afrin Fatima Fazal Abbas Sayyad in writ petition number 6096 of 2021. And it is stated one second, no, not this one. Yes, Sanchit Software and Solution Private Limited in writ petition number 783 of 2012. This is an order dated 7th September 2012. And the Honorable High Court says that in any civilized system, the SEC is bound to pay the tax which is liable under the law to the government. Government, on the other hand, is obliged to collect only that amount of tax which is legally payable by the SEC. The entire object of the administration of tax is to secure the revenue for the development of the country and not to charge SEC more tax than that which is due and payable by the SEC. And they also refer to a circular which is a 1955 circular, 11/4/1955 circular, which says that the officers of the department must not take advantage of ignorance of an SEC as to his rights. It is one of their duties to assist a taxpayer in every reasonable way, particularly in the way of claiming and securing reliefs. And in this regard, the officer to take the initiative in guiding a taxpayer where proceeding or other particulars before indicate that some refund or relief is due to him. And they should freely advise them so that their rights and liabilities are not denied. There is another judgment also of the Honorable Madras High Court, which also takes the same view that even if some error is committed, the power under 264 is such that it is to set right things wherever he finds that an injustice has been done to the SEC. Now, another judgment of the Honorable Andhra Pradesh High Court said that the power under 264 of the Act is in fact a wide power and one that is prevented to prevent miscarriage of justice. Courts have consistently taken a view that conferment of power under 264 of the Act is to enable the Commissioner to provide relief to the SEC where the law permits the same. So, it is the bounden duty of the officer concerned to ensure that there is no miscarriage of the justice. And if the law permits, if there is any relief within the four corners of the law, then that benefit must accrue to the SEC, whether he has claimed it in the return, whether in fact he has made a claim before the commissioner concerned also. But if it discovers that, look, this is the error committed by you in the filing of the return, you should have claimed this deduction or you should have claimed this relief, which you have omitted to do so in the return. In fact, even in your application before me, you have not made that claim. Even then, he should guide the SAC. So forget about me making a claim. It is his duty that no tax should be collected which is beyond the boundary of the law. Otherwise, it will be violation of Article 265. And therefore, even if some error is committed in the return, the commissioner is very much within his not only rights to rectify that error, but rather he has a duty to rectify that error.
So if you could please tell us what is the difference between section 263 and 264, because both these provisions give commissioners the power. Now, what is the fundamental difference as to section 263 and 264 of the Income Tax Act?
So fundamentally, you see, 263 is a suo motu power given to the commissioner if he finds that there is an order passed by the authority subordinate to him or her, which is prejudicial to the interest of the revenue. The SSC cannot make any application, or even the income tax officer cannot make an application. It is a suo motu power. 264, on the other hand, is power to correct orders which is prejudicial to the interest of the SSC. Therefore, the commissioner should not pass an order which is prejudicial to the interest of the SSC. So, the power under 264 is to protect the interest of the SSC. It is to give protection to the interest of the SSC. And this power can be exercised suo motu on his own motion or on an application by the SSC also. So, even an application, SSC can approach subject to condition prescribed in the law. Secondly, the time limit under 264 is completely much more. So within 1 year from the passing of the order, 264 application can be made by an SSC, whereas the appeal can be filed only within 30 days.
So suppose an assessee files a commissioner appeal, so files it within time. It is pending before the commissioner appeals. Now, for some reason, he wishes to withdraw that appeal and prefer a revision under section 264, but the time limit of 1 year has elapsed. Then, in this case, sir,
Even if 1 year has elapsed, the commissioner has the power to condone that 1 year elapse if sufficient cause is so. So that is very much permissible. But simultaneously, two remedies cannot be pursued for sure. Only if the commissioner appeal allows the withdrawal, then only he can approve the commission.
thank you, sir. Are there any other questions?
But in my view, I mean, one should not take that risk of withdrawing the appeal and then approaching the commissioner. One should plan their affair in advance and not take that chance of withdrawing the appeal and all that.
So, what's the meaning? The term they use is complete justice. So, what does the word complete justice, sir, will imply in section 264?
So complete justice means justice which is beneficial to the SSC in the sense that if something he has omitted to make a claim in the return or is entitled to some benefit or relief, then the justice means that justice to give relief to the ordinary citizens. there's no other question, then I guess we can close the session.
So there are no other questions from the participants.
So, okay, thank you very much.
Thank you, sir.